Welcome to the Law GH channel and welcome to our 15th episode on the law of tort. Today we are going to study the principles on occupiers liability. We are going to treat occupiers liability in two parts under this episode. The first part will focus on lawful visitors. The liability of the occupier depends on the character of the entrant. There are two categories of entrants, namely the lawful and the unlawful visitors. Let's now look at lawful visitors. We have four types of lawful visitors, and these are contractual visitors, invitees, licensees, and persons enters as of right. What are the principles under contractual visitors? Essentially, it is that the premises are safe for the purposes contemplated by the parties. In Frances and Cockrell, Kelly C.B. said, "First, there is a principle which I hold to be well established by all the authorities, that one who lets for hire or engages for the supply of any article or thing, whether it be a carriage to be ridden in, or in a bridge to be passed over, or a stand from which to view a steeple chase, or a place to be sat in by anybody who is to witness a spectacle, for a pecuniary consideration, does warrant and does impliedly contract that the article or thing is reasonably fit for the purpose to which it is to be applied. But, secondly, he does not contract against any unseen and unknown defect which cannot be discovered or which may be said to be undiscoverable by any ordinary or reasonable means of inquiry and examination." Also, in McLean and Seeger, McCarty J. said, "Where the occupier of premises agrees for reward that a person shall have the right to enter and use them for a mutually contemplated purpose, the contract between the parties, unless it provides to the contrary, contains an implied warranty that the premises are as safe for that purpose as reasonably care and skill on the part of anyone can make them. The rule is subject to the limitation that the defendant is not to be held responsible for defects which could have been discovered by reasonable care or skill on the part of any person concerned with the construction, alteration, repair, or maintenance of the premises." And the head note to Frances and Cockrell must to this extent be corrected. But subject to this limitation, it matters not whether the lack of care or skill be that of the defendant or his servant, or that of an independent contractor or his servant, or whether the negligence takes place before or after the occupation by the defendant of the premises. Thus, in Gilmore and London County Council, where persons were invited to engage in some form of physical exercise on the premise, Lord Duparc explained further by saying, "The question is, I think, whether it is a reasonable, safe law to use when one is inviting people to come and make use of it for physical exercises of this kind. I am not sure that one can apply to a case of this kind the rule which has been pressed upon me, associated with the case of McLean and Seeger. I think that the proper way to put it is this. If any person or body of persons invite a man for reward to take part in physical training and invite him to come for that purpose to the premises which they have hired, of which for the time being they are in possession, then in those circumstances that person or body of persons impliedly warrant that they have taken reasonable care to see that the premises are in all respects reasonably safe for the purpose." Lastly, in Bell and Trafco Hotels Limited, Lord Goddard C.J. summarized the principle as follows. "The standard of care required of a hotel keeper under his contract with a paying guest in respect of a well-made drive a quarter of a mile in length which formed part of his premises was only to take reasonably care to see that the drive was reasonably safe for foot passengers to walk on, that the defendant had taken such reasonable care, and that there was no unusual danger. The judge, I think, took the view that because this lady could and did slip, since undoubtedly one could slip at that place, he ought to hold that this was a dangerous place, and he applied the standard of care laid down by McCarty J. in McLean and Seeger. That where one person receives another onto his premises for reward, there is an implied warranty that the premises are safe as reasonable skill and care can make them. McCarty J may have been right in applying that standard of care to the interior of a hotel. But if one is to apply that standard to a drive a quarter of a mile long and say that every portion of that drive has been made as safe as reasonable skill and care can make it, it seems to me that it will have to be applied similarly to every part or place in the grounds of a hotel. The most satisfactory test to apply in a case like this is the standard which Duparc LJ laid down in Gilmore and Loudoun County Council. If any person or body of persons invite a man for reward to take part in physical training and invite him to come for that purpose to the premises which they have hired, of which for the time being they are in possession, then in those circumstances that person or body of persons impliedly warrants that they have taken reasonable care to see that the premises are in all respects reasonably safe for the purpose. In all, to escape liability under the contractual visitor principle, the occupant must establish that the defect was unseen and unknown defects which cannot be discovered or which may be said to be undiscoverable by any ordinary or reasonable means of enquiry and examination. Let's now look at invitees. The duty is that an occupier must take reasonable care to prevent injury to the invitee from unusual danger of which he knows or ought to reasonably know. In Indemore and Dames, Wills J. laid the principle that, inasmuch as the plaintiff was upon the defendant's premises on lawful business, in the course of fulfilling a contract in which he or his employer and the defendant both had an interest, and the whole or shoot was from its nature unreasonably dangerous to persons not usually employed on the premises, but having a right to go there, the defendant was guilty of a breach of duty towards him in suffering the whole to be unfenced. And with respect to such a visitor, at least we consider it settled law that he and that where there is evidence of neglect. The question whether such reasonable care has been taken by notice, lighting, guarding or otherwise, and whether there was contributory negligence in the sufferer must be determined by a jury as a matter of fact. Also, in Griffiths and Smith, Viscount Simon L.C. held the neglect or default proved against the managers in respect of the flaw was neglect or default in the exercise of their statutory duty. That the appellant was an invitee and not a mere licensee. The appellant had to show that the managers were in occupation and control of the premises and were therefore under a common law duty to the invitee to take reasonable care to prevent injury to the latter from a hidden danger of which as occupiers they should have been aware, or to warn the invitee of the existence of the danger. Thus, the claim is simply on the well-known principle of Indemore and Dames. Remember from the decision of his lordship in this case, and quoting Tucker J. in the first case cited under invitee, it is said that for invitee, the occupant must have a material interest in inviting the plaintiff to the premises. Crucially, in Walker and Midland Railway Company, Earl of Selborne emphasized that, I think that it is impossible to hold that the general duty of an innkeeper to take proper care for the safety of his guests extends to every room in his house, at all hours of night or day, irrespective of the question whether a guest may have a right or some reasonable cause to be there. The duty must, I think, be limited to those places into which guests may reasonably be suspected to be likely to go, in the belief reasonably entertained, and that they are entitled or invited to do so. Let's look at the decision in Pearson and Coleman Brothers, per Lord Green M.R. in extensa. The plaintiff was an invitee to the circus and wandered about not out of curiosity, but in a reasonable way in search of a secluded spot to relieve herself. But she must be taken to have reached the spot where she was injured, pursuant to the original invitation to the circus. It was impossible to say on the facts found by the county court judge that the zoolager had been sufficiently marked off to show the child that it was a prohibited area. The problem is not to find out when the little girl became a trespasser, but to find out when she ceased to be an invitee. She began as an invitee. She paid her shilling. She was invited to a place where anyone will know that among the spectators in a circus of that kind, there will be bound from time to time to be people who would find it necessary to go outside somewhere and relieve themselves. No place was provided for that purpose. It does not surprise me or shock me in the least to suppose that as what is in effect a country circus put down in a field, the patrons are expected to look after themselves and find some place where they can satisfy their needs. This is not a London cinema, it is a country circus in a field, and the rustic and primitive method of dealing with such an emergency would be perfectly natural in what the proprietors would contemplate. What was she to do? Mr. Rhys Davis could only suggest that she might have found an attendant. We do not know what attendants were there, where they were located, and whether it was possible for a little child to get hold of one in what I dare say was a crowded circus tent. In my opinion, if a landowner is minded to make part of his land a prohibited area, he must indicate this to his invitees by appropriate means. It is no good his coming afterwards and saying, "You were not allowed to go on that piece," if in point of fact he has done nothing or nothing adequate to show that the second piece of land is a prohibited area. Whether or not proper and sufficient steps have been taken to delimit the prohibited area must I apprehend depend on the facts in each case. Looking at the zoo, which in this case is said to be a prohibited area, I find what I have described as a rough and ready manner of marking it off and indicating that nobody ought to go in there unless he goes through the proper entrance. It is a rough and ready method of doing it, and to an adult it might be very well regarded as sufficient indication that the area of the zoo is a prohibited area and is not accessible to anyone who does not go through the proper entrance. But we are not dealing here with an adult, but with a child who is not moving about out of mere curiosity or without any reason. We are dealing with a child in a condition which the proprietors must have contemplated as a reasonably possible, namely the condition of being under an urgent necessity to find a quiet place in which to relieve herself. Lastly, in Mersey, Docks and Harbour Board and Proctor, where the House of Lords held inter alia that the failure of the appellants to keep the chain in position was not a breach of any duty owed by them to the deceased, and that the action must fail. The takeaway from this case is that it is clear also therefore that an invitation may be limited as to place and as to time, so that customers may not be considered as invited after the shutters have been let down. Let's now look at the principles for licensees. Here, the duty of the occupier is to warn the licensee of concealed dangers actually known to him and not known to the licensee or obvious to him. In Mersey, Docks and Proctor, Lord Sumner held that a licensee takes premises which he is merely permitted to enter as he finds them. The one exception to this is that the occupier must not lay a trap for him or expose him to a danger not obvious nor to be expected there under the circumstances. If the danger is obvious, the licensee must look out for himself. If he will walk blindfold, he walks at his peril, even though he is blindfolded by the action of the elements. As usual, in cases of duties of care, the reasonable man is the standard on both sides. The licensor must act with reasonable diligence to prevent his premises from misleading or entrapping a licensee, who on his side uses reasonable judgment and conduct under circumstances that can be reasonably foreseen. The licensee is to take reasonable care of himself and cannot call a thing a trap, the existence of which a reasonable man would have expected or suspected so as to guard himself from falling into it. Thus, in Fairman and Perpetual Investment Building, where the licensee was unsuccessful, Lord Sumner held the only duty owed by the defendants, the plaintiff, was not to expose her to a concealed danger or trap, and so her action failed. Per Sherman J., though he does not use the word trap, to my mind clearly meant that the facts did not raise that kind of liability on the part of occupiers or controllers of premises towards person coming onto them with their permission, express or implied, which is commonly so called. The stairs were well lighted, and after slipping, the plaintiff looked and saw the cavity in the step. She could equally have seen it and have seen it equally well if she had looked before she slipped. She was fully familiar with the stairs. The spot was not a dangerous spot. The cavity was substantially in the same condition in which it had been for a long time. She slipped because she caught her heel and not because the step or anything in it was slippery at the moment. In Laurie and Walker, Lord Lurban, Elsie also held that the effect of the learned judge's finding being that the appellant was in the field without express leave, that with the permission of the respondent, the appellant was entitled to recover. I think in substance it amounts to this. The plaintiff was not proved to be in this field of rights, that he was there as one of the public who habitually used the field to the knowledge of the defendant, that the defendant did not take steps to prevent that user, and in those circumstances, it cannot be lawful that the defendant should, with impunity, allow a horse, which he knew to be a savage and dangerous beast, to be loose in that field without giving any warning whatever, either to the plaintiff or to the public, of the dangerous character of the animal. Lastly, in Morgan and Incorporated Central Council of the Girls Friendly Society, Horwich J. held that the plaintiff was a licensee of the defendant. The negligence was that of the independent contractors and not of the defendant. There was no trap of which the defendant knew or ought to have known. The plaintiff in this case was a licensee and not an invitee. He was an invitee of a firm of architects whose office he was going to, but not an invitee of the landlords, the defendants. In this case, the defendant created no trap. The trap was not discovered by the people who ought to have discovered it. No concealed danger existed of which they knew or ought to have known because they employed competent people to advise them. From the lesson, we could now summarize the principles for the establishment of each of the above lawful visitors as follows. Contractual visitors. There is an implied warranty on the occupant to ensure A. That the article or thing is reasonably fit for the purpose to which it is to be applied. B. That the premise is safe as reasonable care and skill on the scale of which anyone could make them. C. A proof on the part of the occupant that he has taken reasonable care to see that the premises are in all respects reasonably safe for the purpose and that there was no usual danger. D. It matters not that the negligence is that of the occupier's servants or independent contractors. And E. Where there is any unseen or unknown defect which cannot be discovered, or which may be said to be undiscoverable by any ordinary or reasonable means of inquiry and examination, then the occupant will not be held liable. 2. Invitees. A. That the plaintiff must use reasonable care on his part for his own safety. B. The plaintiff has to show that the defendant was in occupation and control of the premises. C. The occupier shall use reasonable care to prevent damage or injury to the plaintiff from unusual danger which he knows or ought to know. Or D. That the occupant took reasonable steps to warn the invitee of the existence of the danger. E. However, that the duty on the occupant must be limited to those places into which guests may reasonably be suspected to be likely to go, in the belief reasonably entertained that they are entitled or invited to do so. F. That the sufficient and clear notice must be given in appropriate means if an occupant is minded to take part of his premise, a prohibited area. G. He must indicate this to his invitees by appropriate means. And H. Whether or not proper and sufficient steps have been taken to delimit the prohibited area must depend on the facts in each case. The third is for licensees. A. That a licensee takes premises which he is merely permitted to enter as he finds them. B. However, the occupier through reasonable diligence must not lay a trap for the licensee, expose the licensee to a danger not obvious, not to be expected there under the circumstances. C. That the licensee must look out for himself if the danger is obvious. And D. The standard of proof is the reasonable man as usual in cases of duties of care. This is the end of part 1 of our 15th episode. We hope you learned and you'll join us for our next episode on the law of tort. Please help us share this channel to everyone. Like our videos, comment and subscribe. Thank you.